Welcome to Dr. Jae Francis YouTube channel. If you receive a request for evidence or notice of intent to deny due to visa fraud or misrepresentation, you're not alone. You may still have a path forward. In this video, we'll break down everything you need to know about I-601 waiver for misrepresentation in U.S. immigration, including who qualifies, when it's needed, and how to increase your chances of approval. Stay with me. This could make or break your immigration case. Hi, I'm attorney Jae Francis. I'm a U.S. immigration lawyer based in Chicago and Wisconsin, but serving all 50 states. Number one, what is 601 waiver and when is it required? The 601 waiver, officially known as application for waiver of grounds of inadmissibility, is often required when someone applying for a green card, whether through consular processing or adjustment of the status, is found inadmissible to the United States. One of the most common grounds of inadmissibility that triggers need for a waiver is a finding of willful misrepresentation or fraud. There's other types of inadmissibility and then other types of 601 waiver, but today we're going to really focus on misrepresentation and fraud 601 waiver. So this might come up during your marriage-based green card process or family-based immigrant visa petition. For many applicants, this happens unexpectedly, often after receiving a request for evidence or notice of intent to deny from USCIS. Or it can be from consular post if you're going through consular process. So, when do you actually need a 601 waiver, the misrepresentation waiver? I'm going to give you 3 common real examples for this 601 misrepresentation waiver. Let's say you and your spouse is a U.S. citizen, apply for marriage green card case, but you entered the U.S. on F1 student visa, but never attended a single class. When USCIS finds that your true intent was never to study or something else, then you may be found inadmissible for misrepresentation. Or you enter the U.S. on B2 tourist visa, or change your status from B2 to F1 or J1, another non-immigrant visa category in the U.S., but you work without authorization in the past, and you never disclose this when you renew or apply for tourist visa, or when you submitted 539 change of status. That past unlawful employment can trigger a misrepresentation finding. Or you apply for non-immigrant visa overseas, can be tourist visa, for example, but falsely stated that you are married or unmarried to gain immigration benefit, to enhance the chance of getting your non-immigrant visa approval. When discovered, USCIS will discover this, that false statement could lead to denial without a waiver. You need a waiver. If any of these situations apply to you, 601 waiver might be your only option to move forward with your immigration case. Number 2, can misrepresentation be waived? It means that will it be forgiven by immigration agency? The answer is yes, but only in specific circumstances. Even if you lie to the government verbally or in writing, you have to meet certain requirements for that misrepresentation to be forgiven. So to make it simple, not everyone is eligible for 601 waiver. Misrepresentation or visa fraud can only be waived if you meet 2 essential requirements. Number 1, you must have a qualifying relative. I'm going to talk about this right after this. And number 2, you must prove that your qualifying relative would suffer extreme hardship, not you, your spouse. Qualifying relatives and other, we'll talk about these qualifying relatives in more detail. If you're denied your green card or forced to leave the United States. So it's about qualifying relatives, extreme hardship, not yours. Without meeting both of these requirements, your waiver and your immigrant visa petition or adjustment of the status application will be denied. Number 3, who is a qualifying relative for 601 waiver? 601 waiver. For 601 misrepresentation waiver, a qualifying relative is defined only as a U.S. citizen or lawful permanent spouse or parents. So I'm going to repeat one more time. U.S. citizen or lawful permanent spouse or parents. Now, the following information is critical. Just pay attention to this. U.S. citizen children do not count as qualifying relatives under this specific waiver, although their hardships can be considered as a part of overall hardship to the spouse or parent. So, your U.S. citizen child over 21 may file I-130 petition for you, but your U.S. citizen child cannot be a qualifying relative. You need to find U.S. citizen or permanent resident spouse or parents for you. So this means that if you're applying for waiver based on hardship to your U.S. citizen child alone, you will not qualify. But if your U.S. citizen wife or green card holding mother, for example, depends on you emotionally, financially, or for medical support, their suffering can be foundation for your successful waiver case. Number 4, what is extreme hardship and how do you prove it? Extreme hardship is not the same as like regular hardship, or I'm gonna miss my spouse. USCIS wants evidence that your qualifying relative would face hardship beyond what is normally expected when the loved one is removed from the United States or denied a green card. So, here are some of the strongest types of evidence to support extreme hardship of your qualifying relatives. I'm gonna, give you the list. Serious medical conditions that require your care or emotional support. Financial dependency, such as your spouse losing income or housing if you leave the United States. Psychological or emotional distress, especially when tied to past trauma or anxiety disorders. Country condition in your home country, it means that waiver applicants, foreign applicants, that would endanger your spouse or parents if they relocated with you to your home country. Educational disruptions or language barrier would affect your qualifying relatives' life abroad. For example, you speak only Spanish, your spouse doesn't speak any Spanish, then it can be very challenging. Maybe your spouse speaks some Spanish, but not much, right? You must submit medical records, psychological evaluation, affidavits, financial documents, and expert reports to build a compelling case. USCIS reviews these claims closely and very, very critically. A general emotional statement is not enough. So once again, I'm going to miss my spouse. It's not enough. Your evidence must be specific, credible, and well documented. Number 5, what are the 3 key aspects of successful 601 misrepresentation waiver? To improve your chances of winning a misrepresentation waiver, you must focus on 3 core strategies or principles or approaches I'm going to lay out for you. Number 1, credibility and candor. Own the mistake. USCIS does not reward dishonesty. Don't try to cover up or say that, well, my agency lied on the application, which may be true, but you need to be responsible for this misrepresentation because it's your visa application in the past, for example. If the misrepresentation happened many years ago, explain the circumstances, show remorse, say I'm sorry, and demonstrate rehabilitation. A detailed, honest declaration or statement is critical. Number 2, well-documented extreme hardship. Don't rely on generic hardship claims. So once again, I'm going to miss my spouse, will not work. Use concrete evidence, hard evidence, objective evidence. Include third-party letters, expert reports, and legal arguments connecting your qualifying relative's situation to your presence in the U.S. And finally, strong legal brief or argument. Legal argument prepared by experienced immigration attorney can make all the difference. The brief should connect the facts of your case with the latest immigration cases and policy guidance to show that your waiver is legally, factually justified. Number 6, does the timing and location of your case matter when it comes to 601 misrepresentation waiver? Answer is yes. Timing and location will significantly impact your case. Yes, of course. If you're applying for adjustment of the status and receive a notice of intent to deny, we call it NOID, due to misrepresentation, you typically only have 30 or 33 days to respond. Tight schedule, very tight schedule. In some cases, this issue may be raised through request for evidence. So instead of coming in the form of NOID, you may get RFE. This will give you 87 days to apply. It's a little bit more time. A well-prepared 601 waiver response during this stage will prevent denial and keep your case on track and eventually approval. Meanwhile, if you're applying from outside consular process and you're found inadmissible during your immigrant visa interview, you must file 601 before your visa can be issued. So, if you go through consular process like CR1 spouse visa, 601 waiver will be handed down to you, if applicable, only after interview. You're not able to do it proactively. In general, 601 waivers processed through adjustment of the status within the United States are adjudicated by the USCIS faster than those filed through consular process abroad, or those of you who's attending consular process interview. Number 7, Let's recap. The 601 waiver process is complex, but success is possible with the right preparation. If you've been accused of misrepresentation or you're applying for a green card and suspect a past visa issue could trigger a waiver, now is time to act. Understanding who qualifies for 601 waiver, identifying your qualifying relative, and preparing a compelling extreme hardship argument can make a difference between approval and permanent separation from your family. If you found this video helpful, please like, comment, subscribe for more information, immigration updates, real case insight. For personalized guidance on 601 waiver or marriage-based green card case, visit our website and call us on the phone number you see on this video to schedule a consultation with us. I will make more videos on 601 waiver cases later. Thank you for watching this video. Peace be with you.